matter of the state of Maharashtra and others versus PRISM Cement Limited and another, Supreme Court dismissed the appeals and stated that the state government was not competent to issue the impugned notices for revising the assessment of the SSC respondent and to demand the exempted tax only for the reason that the SSC respondent has not submitted Form C and D in support of interstate sale, trade, and commerce. The requirement of the submission of these forms would apply prospectively after the Finance Act of 2002, and in the opinion of the Supreme Court, the appeal lacked merit. The court held that the SECI respondent was held eligible for absolute exemption under the PSI 1993 issued in exercise of power under Section 8(5) of the CST Act as per eligibility certificate dated 20 February 1998 and entitlement certificate dated 24 March 1998 granting exemption to it from payment of tax under the BST Act and the CST Act to the extent of 273.54 crore rupees or up till 2012, whichever was earlier. The said exemption granted to the SSC was much prior to the enforcement of the Finance Act 2002 with effect from 11 May 2002. Therefore, by virtue of unamended sections 8(5) and notification issued thereunder, as well as under the aforesaid eligibility and entitlement certificate, a substantive right of exemption from payment of tax had accrued to the SSC. The contention was that though after the amendment the right of the government to grant absolute exemption has ceased to exist, but that is only prospective in nature and would not apply to cases where an absolute exemption without any restriction has already been granted. The amended act nowhere stipulates that the rights previously accrued stand nullified or all previous exemptions stand cancelled or revoked. The requirement for fulfilling the conditions of Section 8(4) of CST Act for getting the benefit of tax exemption came subsequently after the amendment of Section 8(5) with effect from 11 May 2002 and would apply prospectively to transactions in respect of which eligibility and entitlement certificates were issued subsequently. Reliance was placed upon Darshan Singh versus Rampal Singh and another, which provides that the benefits conferred earlier to the amendment would remain unaltered. However, the availment of the said benefit in future would be restricted to conditions imposed by the amended provision. It is a cardinal principle of construction that every statute is prima facie prospective in nature unless it is expressly or by necessary implication made to have retrospective operations. Unless there were words in the statute sufficient to show the intention of the legislature to affect existing rights, it was deemed to be prospective only. In S.L. Srinivas, Jute Twin Mills versus Union of India and other, the court had quoted the observation of Lopes L.J. Every statute, it is said, which takes away or impairs vested rights acquired under the existing laws or creates a new obligation or imposes a new duty or attaches a new disability in respect of transactions already passed must be presumed to be intended not to have retrospective effect. The law is settled that if a substantive right has occurred to a person, it cannot be taken away unilaterally without notice or an opportunity of hearing to the said persons. Thus, after the amendment of Section 8(5), the government was not authorized to pass a unilateral order affecting the rights of the SECI respondents for claiming absolute exemption from payment of tax. The SECI respondent was not given any notice, either cancelling the eligibility certificate or the entitlement certificate. Therefore, without revoking the said certificates, the substantive rights which had accrued to the respondent thereunder continue to subsist and do not get impacted by the subsequent amendment of Section 8(5), in as much as there is nothing in the amended provision which provides for taking away such rights to the respondents.